All right, good afternoon, council's interested parties. We're back on the record in the matter of the state of Georgia versus Cuniff Adams et al. in 22 SC 183-572. All right, Mr. Stillwell and Mr. Botts and Mr. Sharp, good afternoon, gentlemen. Good afternoon. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Ms. Renard, good afternoon. All right, Mr. Kendrick and Mr. Weinstein, good afternoon. All right, Mr. Ewing, Mr. Matthews Jr. and Sr., good afternoon. All right, Mr. Nichols, Ms. Westmoreland, Mr. Harvey, is Mr. Garner behind that? No, Mr. Garner. Okay, all right, good afternoon. All right, Mr. Ryan and Ms. Williams, good afternoon. All right, Ms. Hilton, Ms. Love, Mr. Atkins, and Messrs. Smith and Brown, good afternoon. All right. All right, so any more jurors here?
Yes, sir. That's good.
Okay. All right, is Detective Belknap in he's there? Okay, all right. Anything I need to take up before I call him? I'm just being kind. I'm really not interested in taking up anything, but where is it, Mr. Sharp, since you were first?
Your Honor, the state sent all defense counsel a video, and my understanding is it's marked 60W. It's not been admitted into evidence. And my understanding is they plan to play this video through Investigator Belknap. The defense, Mr. Stillwell, as well as all the other defendants, do have specific objections to the introduction and publishing of this video. And I want to voice those concerns and make those objections now while the jury's still not with us.
What is CCW report to show, Mr. Sharp? And then,
Come up.
yes. That's my first question. And then the second question is what specific objections do you have as to it?
Well, Your Honor, I am not certain as to the reasons why the state seeks to introduce it. I will say that this video...
Answer my first question.
What's the
video purport to show?
The video, I believe, shows a number of individuals. I'd put it around 20 that are hanging out in what appears to be a parking lot. I believe that's outside apartments in the Cleveland Avenue corridor.
Okay, how long is the video?
The video is approximately 15 minutes.
It's about
7 minutes.
Okay, all right, 7 minutes. And then what's anything else about this video on these alleged 20 individuals in this parking lot?
So there's a definitely, I would say, a general main narrative whose gentleman is not one of the accused. I think I may know who he is, but I wouldn't want to say that with certainty. He's kind of narrating, this is what we're doing, this is what's going on, and just kind of, I would say, puffing for the camera. There are other individuals smoking marijuana, leaning on cars and whatnot. There's a young lady who's saying that she's the only lady that's present, and she's speaking to the camera. Mr. Williams, I believe, makes an appearance on the camera for a short time. I don't believe any of the other charged individuals appear on the video. There are other people who I know the state has alleged are co-conspirators or YSL associates that appear on the video. They're not the ones that are talking. Generally, I believe that an individual by the name of Quindarius Zachary at one point has a firearm in his possession. There are individuals with firearms, just to be candid with the court. So it's marijuana, it's firearms, it's cussing, and bragging and the sort of thing. This is how we do it in Cleveland Avenue. You know, this is our neighborhood type thing. There are several reasons why I do not believe that this should be admissible, Your Honor.
Okay, what are your reasons for the objection?
Okay, well, first of all, just generally, I think that there's a lack of relevance towards issues that this case is about. There's certainly bad character evidence. There's certainly people in possession of firearms. There's certainly people using bad language. There's certainly people smoking marijuana. Those are all bad character that would be prohibited generally under 404A. Additionally, Your Honor, to the extent I believe in full candor, that there's what the state is going to allege some sort of gang signs, and also a brief mention about sex, money, murder, or SMM by Mr. Williams. I believe that those aspects we've heard We've seen through Detective Belknap, we've seen Mr. Williams' tweets. We've seen multiple videos, one outside a house in the Cleveland Avenue area with the young child. We've seen two videos, I believe, of Mr. Stevens riding around in a car, rapping along with rap lyrics, saying what's alleged to be gang jargon. We've seen another video in a parking lot area with people sitting on a car. We've seen another video with Bloody J pre-video shoot where Mr. Williams, Mr. Stevens, and other individuals are saying many of these same things. Sex, money, murder, blood stuff, firearms. We've seen the tweets to the Young Thug account, and we've also seen Mr. Eppinger's Facebook page. I think the state has presented evidence of that they're going to argue links some of these individuals to gangs. At this point, playing another video of people with possession of firearms and smoking marijuana and hanging out and saying things that typically you would not want a defendant to say in front of a jury, at this point is the probative value of any issue in this case is scant. It's not relevant. It's extremely cumulative at this point. We're not, and this, let me be clear, Your Honor, I'm not saying that this is the court's fault, but I'm saying in playing additional videos, it's cutting back on judicial efficiency, and it's cumulative at this point. So we believe that under the 403 balancing test, the relevance and the probative value is outweighed by the danger of unfair prejudice, substantially outweighed. Also, Your Honor, there is hearsay on this video. As I said, this narrator who has not been identified, has certainly not been named in this indictment, is just going on and giving a narration. He's not on a witness list to my knowledge. He's not testifying in court. It's hearsay, it's confrontation clause. There's no judicial finding whatsoever that these statements in this video would qualify under statements by a co-conspirator 801 D2E. So the state has not laid the foundation for the admission of any of these out-of-court statements. So, Your Honor, we just don't see the relevance, and we would ask that for those reasons, the state not be allowed to play the video. Should Your Honor feel that it's appropriate to play an additional video that shows the same sorts of things we've already seen through the other videos, we would ask that the state, that this video be redacted to limit the publishing the video to the salient points to actually issues in this case, as opposed to just playing a video of a bunch of young people in a parking lot smoking marijuana and cussing.
Okay. All right. Thank you, sir. Madam, Ms. Hilton.
Thank you, Your Honor. Your Honor, with this video, and if the court wants to see the video, we have it ready to be played. This is a 7-minute video that we received from Investigator Belknap, and the state intentionally did not put the video in during our initial direct examination of Investigator Belknap. However, we believe this video has become relevant given the cross-examination that has occurred at this point of Investigator Belknap. Specifically yesterday, Mr. Steele, in his line of questioning to Investigator Belknap regarding the tweets, as well as even State's Exhibit 55W, there was this inference again that Mr. Williams is only doing this for promotion, to promote his music career, to promote that he's not a real gangster, but that he is a studio gangster and is promoting this lifestyle, so it's not really accurate. This video, Your Honor, is not a music video, which is a little different from State's Exhibit 54W. This is a video, I believe from 2012, in which Mr. Williams, as well as Trontavia Stevens, as well as Walter Murphy, who are all co-conspirators in this case, in addition to some witnesses we believe will be coming up in momentarily, Quindarius Zachary, are all in this video. They are in an apartment complex in the Cleveland Avenue area. A number of individuals are wearing red or have red bandanas, and Mr. Williams specifically, I believe Mr. Murphy and Mr. Stevens all are throwing up sex, money, murder symbols. The symbol for Pistol Pete. Mr. Williams himself actually says that he is a member of SMM, which would, again, going down the line of questioning that happened yesterday, would refute, we believe, is evidence refuting this notion that Mr. Williams is a studio gangster. And the state's position is that Mr. Williams, along with other members of YSL, are real gangsters. They're actual gangsters, nothing studio about them. And so we believe that this video is relevant to to that particular portion. Mr. Shaw.
Assuming it's relevant, okay, I take your threshold issues to relevancy. What about the issues of the narrator being hearsay, the 403 and potentially confrontation clause issues?
Your Honor, because this is a party opponent admission, Your Honor.
By whom?
Mr. Williams.
Okay, what about you got Mr. Williams, you got Mr. Stevens, you have Mr. Quindarius Zachary, and then you have three of them.
Yeah.
And four of them. I think Williams, Murphy, Stevens, and Zachary, right?
Yes.
Okay, as to those, what about the other speakers?
So what we would argue, Your Honor, I'm going to direct the court to United States v. Perry, and I'll have to get the site for you. It may be 14/4/1253.
I'm sorry, what is it?
It's going to be United States v. Perry, 14/4/1253, which is the 11th Circuit 2021 case. And this is regarding a telephone conversation. However, I think we can be comparable to this video. And in that case, it says it held that while the defense assertions during the recorded telephone conversations were admissible under 801D2A, which is a party opponent admission, those made by others during the same conversation were admissible to show their effect on the defendant. Without hearing other speakers' side of the conversation, defendant's statements would have been rendered meaningless. It also says the inclusion of a non-party statement was necessary for the jury to fully understand the defendant's statements, Your Honor. So we believe in looking at the entire video, it puts into context what Mr. Williams is doing in the video, what Ms. Murphy, what Mr. Stevens are all doing in the course of that video, Your Honor. So we believe that the entire video should be able to come in.
I need to look at it seems like most of the conversations in Perry were by the co-conspirators themselves and the client shared.
And let me say, unknown speaker, Investigator Buckner may know who the speaker is.
I'm sorry?
Investigator Buckner may know who the speaker of the video.
Do you know who it is? Does he know who it is? Have you seen the video?
He's seen the video. He's the one who provided it to us. And he provided the video to us. And I don't know if I said an unknown speaker. I just said the non-party speaker was admissible.
Well, in Perry, unlike what you have in our case, Perry involves co-conspirators. I mean, they're definitely having conversations between them amongst themselves. So that a little different than what you have in this video. You've got you've got 4 people that are involved in your case. You've got several others that are not.
There are several others who are not, but there are several other, all of the individuals we believe were part of Rock Crew at the time. And as Rock Crew was the early iteration.
Even you know they are.
From the video, they claim that. This is the whole video when each of these members claim affiliation with Rock Crew, which is the earliest iteration of YSL back in 2012. And so we believe in the general conspiracy of the gang of Rock Crew that they would all be co-conspirators because each of them claims affiliation with Rock Crew, specifically in this video.
Okay. And how are you saying their statements are admissible? The people that are there, they're not charged in this indictment.
Because they would be co-conspirators of the larger general conspiracy of the criminal street gang of Rock Crew. And so that would come in under the co-conspirator exception to the hearsay rule. And I know that Mr. Sharp mentioned this is confrontation clause.
If it's conspiracy, it doesn't.
Yeah, and none of this is confrontation because none of this is testimonial to police or law enforcement. Only if it was testimonial would it be.
All right, Mr. Sharp, anything else?
Yes, Madam First of all, factually, I would push back on the state's assertion that all of these people are Rock Crew associates or express so on the video. I think that's very much of an overstatement and a generalization. I don't believe that every person that speaks does that. Second, we talked about statements by admissions by a party opponent. And we put Mr. Williams in that bucket, and I understand that. We also put Quindarius Zachary. He's not a party opponent. We put Trontavious Stevens, although he was indicted, he is not a party opponent at this time. And we put another individual as well as a party opponent, and Walter Murphy, and he's not a party opponent right now. So those statements by those individuals would not be admissible.
They're co-conspirator statements.
Well, okay, but that's a different. I was dealing with the party opponent.
I'm looking at that. So
okay, co-conspirator. Well, a few things. You can be a gang member and not be part of a conspiracy.
That's a jury question.
Well, Your Honor, you're the gatekeeper, so it's a judicial question first before the jury considers it.
Okay.
So there's no indication. For the statement by a co-conspirator, it needs to be in furtherance of the conspiracy. There's nothing that is said that could be reasonably.
Well, isn't that the jury's determination to determine whether or not that is whether or not one, a conspiracy exists, and two, whether or not it was made in furtherance of the conspiracy based on the factual predicate that the state has the burden of proving.
No, that's not a jury question, Your Honor. That's like saying,
or the weight of the evidence.
Well, I agree with the weight,
credibility of the evidence, whether or not, but what
I agree with all that, but that's like saying, isn't it a jury question to determine if evidence is relevant? No, it's
No, it's not. It's not.
Yeah, it's yours, and 801 D2E is yours too. You have to make that finding based on specific facts about an individual statement to make it admissible. Again, they're the proponent. They're seeking to introduce things through exception to our general rules of evidence, and they need to make a showing, and they're simply not making it. Additionally, Your Honor, this Perry case, I just want Your Honor to understand is someone, I've watched the video, I know the state has, I suppose you haven't yet, Your Honor. This is not a situation that's at all akin to two individuals talking on a phone, and you need to understand, you need to know what's being said on the other end of the phone call to understand what the party opponent is saying on their end. There's no need for context here. When the state is saying that someone's talking and someone else is talking, we're talking about a camera that's panning to different people. There's no indication from what I saw that this gentleman who's being a general narrator, at least from what I saw, there's no indication that Mr. Williams even heard what the narrator's saying when he says what he said. So it's not someone says something and Mr. Williams says something and we need to know what they said to understand what Mr. Williams is saying. They're completely separate conversations that just happen to be going on within this group of about 20 people in this parking lot on a random day, probably 10, 15 years ago. And I also don't know how the state knows this from 2012. That's unclear to me as well. But, Your Honor, there's no context needed. It's completely distinguishable from Perry. These are not statements in furtherance of a conspiracy, and these are not admissions by a party opponent.
All right. Ms. Hilton, anything else?
No.
Okay, can I see?
And Your Honor, also for the record, we just received, my understanding, we just received this yesterday. That's the first time I saw it, or yesterday or this morning. So, okay, my colleagues are saying that we received it last week. And so that's also an issue, the late disclosure.
All right. Madam, when was it disclosed?
Yes. Investigator Belknap disclosed it to us last Wednesday, and I think I was in court when I received it. As soon as I saw it on Thursday morning, before I even viewed it, we settled it, and Mr. Atkins sent it on behalf of the state. So we were provided to, I think, probably around lunchtime on Wednesday the 31st. I didn't see it. We were in court. Looking at the time of the email where Investigator Belknap sent it, it was probably around the 12:45 hour. I did not look at my email until that next morning. When I received it, we immediately uploaded it to Dropbox and turned it over to defense counsel, which was last Thursday at about 9:45 in the morning.
All right. Judge, Investigator Belknap's their expert witness. They've been preparing this case with Investigator Belknap. I don't think that just because the lawyers haven't received it by a certain date, that's an excuse to hand over evidence that they intend to introduce to the defense counsel at the last minute. I don't believe that is an argument that can stand.
All right, thank you, sir. Sergeant Ingram, can you tell our jurors to be at ease for a little bit, please? Just tell them to be at ease, continue to be at ease. We're still working. Do you have States whiskey, I should say 60 whiskey queued up to the 7 minutes that you're going to propose to show the jury?
Yes, Your Honor.
All right, can I see it?
Yes.
My whole crew got blood. We just want to be for battery, man. Anybody can play with them on trade, they did. You know what I'm saying? Yeah. It's a real rocky movement, man. I got them pounds in on trade.
What time? Oh, you started. All right, I'm going to answer my own question. You started at 000?
Yes, Your Honor. Sorry, at 000.
You can continue at this point.
Hey man, nigga really know.
Look at my face. What's up, you little niggas, man? First later, I wrote 5, man. These bitches ain't my eat when you
We working too. We working on the block. Hey man, what most of y'all niggas ran up with, man. My little girl got it on right now, man. Trey, man. She got a car and she ain't even walking yet, and that's on Trey. Hey, too bad. Hey, Rock, good show, man. Hold on, good. The first one good. Go ahead, my screen up. Go ahead and black. Look. Man, what? They gotta get out the car with it on. Give a fuck, man. Bitch. Yeah, ho. Yeah, ho. Let 2 guns up, make a salute. You understand me? Yeah, ho. I be that bloody trouble bringing that sex money murder, man. You know what I'm saying? Shit tatted on me, man. You know what I'm saying? People get beat up, man. Yeah, ho. You tell the sex money murder, man. Crane, cash through everything. But the bitch didn't do, ho. Good weed. I ain't fucked up, nigga. I locked up. If I'm in the nuts, we gotta rotate stuff, man. You understand me? You be spooky. About 10 of them, about 12. This a little trader, man. Y'all niggas man. Hey, man. At this point in time, we yell switch, so everybody just switch. I got to switch to the right. See you right. We had to switch. All right, I will. We had to switch. Don't do that. Everybody got a dope. Yeah. Here you go, so. Bro, y'all pay that shit to John, right? Pay that shit to Shumi. You know, he just said, man, he passing the game, he said, give him an ounce, bro. Yeah. Hey, man. He said, give him an ounce. He said, give him an ounce. We got our apartments on control. Go to the car and get 3-4 ounces. We got our apartments on control. Matter of fact, go to the car and get a pound of yikes. They talking about in a minute. And I'm riding with the chopstick. Hey, I'm gonna show y'all what I'm riding in. Straight up. Y'all see big girl in the shrimp fried rice? Shrimp fried rice a little bit.
With and fruit punch. Man, I'm the only bitch out here in this shit. That's serious. Hello.
Yeah, that big cool battery, man. So, anybody play with them? Ooh. 1426, man. Louis V, everything. Louis V, true. Okay. And Gucci. I'm saying, my family kicking, man. I'm saying, religion, everything, man. Okay. I'm saying, that's my family kicking, man. That big family, man. I'm saying, my brother is Louis. Louis, he said he wants some red bottom tomorrow. I told him no problem, I got him. You know what I'm saying? I don't talk. Anybody who knows somebody who ain't smoking right now, man? I'm talking to Mayday right now. I got weed up. I'm talking to Mayday right now. I'm talking to Mayday, man. We got control on our part. You know what I'm saying, man? We got cameras and shit out here, man. So anybody think they coming through, think they catching them, man. We ain't never slipping, man. We got niggas on walking, talking, man. You know what I'm saying? We got the can lady working. You know what I'm saying, man? Everybody busting for trouble, man. You know what I'm saying? They're my blood brothers, you know what I'm saying? Bees up, pee up and get beat up. Mm-hmm. Oh, yeah. You know what I'm saying? But DKJ got out, and he got it on him. And he got the screen up on him. You know what I'm saying? He just got out yesterday. With my other blood brother, man. You know what I'm saying? We kick shit, blue. This is every day. Oh shit! Check out the trucks. I got ashes on my truck. You know what I'm saying? Half of these niggas ain't got nothing right now, man. You know what I'm saying? These niggas out here every day, man, hustling, man. You know what I'm saying? Look, what you got on you right now, man? It been smoked out, right? Thugger. It's not SWM, it's nothing, man. It's nothing. My family for life. It been smoked out, hey. If it's a 50 in my bankroll, nigga, my mama a bitch. Hey, you heard that, nigga. It been smoked out. Big Val, like she ain't edged over them. What they thought?
Break one iPhone, go to the store and get an all black one for $5.60. You know what I mean? Ain't too many bitches still doing it. Okay?
They been smoked out.
Got no insurance.
I'm being yo, man, of all this sex money shit that's going on this shit. I mean, I'm being still in this motherfucker, man. I hear bloody baby. I hear they know what's poppin', bro. Okay. My whole bro here, nigga. Hey. You ain't not here, man. My whole crew here, man. Straight fuck up. Oh, she robbing or she bullshitting? She robbing or she bullshitting? Look at her hair, man. You with this loud? Look at her hair, man. We go get a room, man. Free my nigga TJ, man. I don't like this dick. I don't know, y'all. Yeah, man. I will find me. You know, we can't like cookies. Get on me.
That concludes the playing at 7:04.
All right.
As you see from the video, it is not just everyone in this entire video is claiming to be a member of, a part of Sex Money Murder, Your Honor. Again, a part of this gang that Mr. Williams, based on a cross-examination, has tried to disassociate himself when going through the tweets yesterday as if he is not a part. And we believe the totality of this video is something the jurors can look at and determine whether or not they believe Mr. Williams or any of the other, Trontavia Stevens, is a part of SMM and the Rock crew, Your Honor. Okay.
I'm just having a tough time, Your Honor, reconciling. The state does not think that tweets made before and after Mr. Williams tweets things out are needed to give the context to his words. But they, at the same time, they're going to sit here and tell this honorable court that some random person giving a 3-minute speech about what he has going on and about buying shoes for his kid if his kid asks, and about his baby having a car but she can't even walk it, is needed to give context to things that Mr. Williams supposedly did on that video. Those two things, in my mind, cannot be reconciled, and I think that the state's arguments are shifting as we go from issue to issue. Perry does not relate, Your Honor. There's a case, Beach v. State, and it's plain error analysis, and ultimately they did not find for the appellant, they did not find plain error, but they did find that the prong of the plain error analysis, they found clear and obvious error to satisfy that prong, and that's 351 Georgia Appeal 237, and that's a case where 351 Georgia Appeal 237, and there's not, just to be clear with Your Honor, in the opinion, there's not a lot of analysis on the prong that I'm relying on it for, but they found clear and obvious error for just playing an entire tape, an interview of the defendant into totality, and not redacting out irrelevant and prejudicial parts of the video. And in that particular case, a prior incident was held inadmissible, but the statement made by the defendant in the tape referenced that prior act, and the court held that it was clear and obvious answer not to redact to eliminate reference to that prior act. It appears in that case, the gentleman may have been representing himself and opened the door to his statement generally. But they said that that references to the inadmissible act should be redacted. So the rule of completeness in just taking something that the defendant did and then just everything around it is automatically admissible. That is not the holding of Beach v. State. And as I said, the state's only presented US v. Perry, which is easily distinguishable from this video. Thank you, Your Honor.
Anyone else have any other argument relates to 60W? Yes, sir.
Good afternoon, Your Honor. Good afternoon, everyone. Your Honor, I would just also, as the court's aware, as the court requires, I would have interviewed people in that video. I got it last week. We've been on trial, so I'll join everything else. But I just want the court to highlight that as well.
Thank you. Anyone else? All right. Can we, I have a question for the state.
Yeah.
Is it possible to redact out the people that are smoking marijuana?
I mean, we can maybe stop and move it, but I mean, we can't remove them from the video. I mean, to me, Your Honor, that's not more prejudicial than probative. I mean, we have, in this case now.
Probative, it's not probative to anything that we have going on right here. I would, over the defense's objection, say that it's relevant. The tape is relevant. You've got several participants and you lay a particular foundation, and the investigator Belknap is going to be able to do that. But the people that are smoking marijuana, I'm concerned about that. That may be improper character. Those people, I mean, unless you, I mean, you got Walter Murphy, not Walter Murphy, but Mr. Stevens is, I mean, but the people that you don't know, that aren't, because I don't think there's anything that's charging in this indictment with marijuana, correct?
No, we do. We have several, we've already introduced several acts of marijuana, especially with Mr. Stevens having marijuana.
But he's already pled.
He has, and he's also already testified as well.
Yes. So what about the other people that are unknown that are in there?
Your Honor, we can send it to our graphics to see how we can try our best to put something over the marijuana smoking. Because there's a portion where Mr. Williams, I think, might be smoking when he comes into the camera view. So I don't know if we're going to be able to capture it.
Well,
But we can either stop or move past that portion where a group of people are just outside smoking.
I mean, there are several pieces of that tape. I think you're going to probably have to redact that tape because for what you have told me that you wish it's relevant to show, there's been an issue about the promotion of his career, but that you've got 4 you're accused in there, Mr. Williams, Mr. Murphy, Mr. Stevens, and Mr. Zachary. There are definitely sex, money, murder symbols and references to Pistol Pete. And Mr. Williams himself says that he makes some references to sex, money, murder. Those are all relevant, clearly relevant. But the other things that are outside of that, outside the 4 that are in there, Unless the detective's gonna identify everybody in there and show that that they're tied somehow to the gang or one of the other elements. What is he gonna tell us? Or what's your understanding as to what he's gonna testify to?
I believe he knows who is the narrator of the tweet. I believe he can identify a number. I'm sorry, I said the tweet. I apologize. He knows.
He can identify people in the video?
He can identify people in the video.
Can he identify their affiliation, or what's he gonna be able to do for those people?
So can I step outside and ask him?
All right,
Because
I'm gonna take a 10 minutes, so I need to take a comfort break, and you can find out from that, okay? I'll make further rulings consistent with that. All right, folks, we're back on the record. Let me see if everybody's here. Anybody missing? Mr. Matthews, where are the Matthews? Can you please get them? Thank you. All right, so I need to better.
Yes, sir.
Okay. All right, thank you, sir. All right, we'll be able to find out from Investigator Bell now.
Yes, Your Honor. He knows about 9 of the individuals in the video. And the state has also identified the areas or the portion of the video that we believe are where the majority of the weed smoking is happening. It looks like they're passing the marijuana around. And there's about 3 portions of the video in which the video is solely focused on that area. And what I've identified is about 0.59 seconds to about 1 minute and 5 seconds in the video is the first portion. Then the second portion is about 1 minute and 41 seconds to 1 minute and 51 seconds. And then the final portion where there's just a large group of individuals just smoking marijuana is about 2 minutes and 14 seconds to 2 minutes and 41 seconds. Now, outside of that, there are other individuals that you might see very quickly. Mr. Stevens smoking, but it's not solely focused on just individuals just smoking marijuana, Your Honor. But those are the 3 areas that I identified. If the defense wants to look at those 3 particular portions and make sure that I identified where there's a large group and all they're doing is smoking marijuana.
Okay, all right.
And we would stop it, move to the next relevant portion, stop and move to the portion.
Can I see the state, Mr. Steele and Mr. Sharp at the bench for me, please?
Yes.
Okay, other than the, so the latest thing is the redaction of the, or the non-playing of the video from those particular sections. Was there anything else that, is it possible to, are you gonna get to it today? And the reason I ask that is because I doubt it.
Right.
And so can you redact it or see if it can be redacted before, so we don't have an issue before tomorrow?
Yes, we'll get with our graphics
Okay.
department and get that
All right.
redacted, Your Honor.
Your Honor, while I do appreciate the court's ruling, I would just like to reiterate, from my perspective, this gentleman who, whether Investigator Belknap can identify who he is or not, whether he grew up in Cleveland Avenue or not, and I'm talking about the first individual who's talking about having a car for his daughter who can't walk and buying red bottoms and the rest. Nothing he says, the state has not shown that he's a co-conspirator. The state has not shown that he's a member of Rock Crew, but even if we accept all those things as true, nothing he says is in furtherance of a conspiracy. And I understand the state is alleging that my client, Mr. Stillwell, is involved in a conspiracy, and people who speak in furtherance of the conspiracy under the law, if that was proven, would be admissible. He is not speaking in furtherance of any conspiracy. And he certainly does not speak on behalf of my client, which is essentially what the co-conspirator statement is based on. All speak on behalf of each other. He's not speaking on behalf of Mr. Stillwell when he's talking about his family and buying, all these cars that he has, that his baby has a car, and buying red bottom shoes. He's not speaking on behalf of Mr. Stillwell. So I am, on behalf of Mr. Stillwell, and I'd imagine the other counsel here, I'm just failing to see how his narrative, which is not needed to provide context, falls under 801 D2E. And we would ask that if this is going to be admissible, we just chop out the first 2 minutes or so where he's just going on and on.
In line with that, there was several references to going to get an ounce, going to get pounds of, and I believe that there's no connection or nexus with respect to the gentleman that are my client who's seated here in this courtroom, the rest of the people that are part of this particular indictment that are seated at these various tables. So to that extent, Your Honor, I ask the court to take that into consideration about the reference to pounds of marijuana and ounces going to get the pounds, things of that nature, sir. Thank you.
All right. Two things. I'm sorry, Mr. Harvey. Want another 105 limiting instruction?
Yes.
Okay, all right, denied. Okay, but now we've cleared that or what else do you want?
Let me relay is my understanding of this particular video. It's undated, but my understanding, and the state will correct me if I'm wrong, is that it is from 2012, which predates the allegations in this indictment. It predates the beginning of the conspiracy alleged in this indictment. It refers to specific groups that are not alleged in this indictment. And if it's in 2012, Mr. Nichols was 17 years old, I believe, at that particular time, had absolutely nothing to do with this or the groups that are talked about in this particular video. So I want to renew my objection to its admission with regard to Mr. Nichols.
I think it's historical. I think that it's a historical development or the issue the state has raised before about Rock Crew, the hybrid nature of gangs, Rock Crew, sex, money, murder, YSL.
So I understand what they've said. My argument is that that doesn't hold water. And I'm renewing that. Number one, that's for the 105 instruction. And we are at the point where Mr. Nichols has been dragged into this evidentiary quagmire, and with all due respect to my counsel, by my co-counsel's cross-examinations in which I did not participate. So what is happening now is that he is suffering a prejudicial spillover, and it is akin to a prejudicial retroactive misjoinder, and therefore I'm asking for a severance. Judicial spillover I am being dragged into unwillingly. So those are my arguments.
Okay.
Excuse me, Your Honor.
Yes, Mr. Weinstein.
I just want to add one thing, and I will be brief. This continued late dribbling out of discovery by the state, is it ever going to end? I absolutely have no reason to doubt that Ms. Hilton did not receive this until February 1st and turned it around and got it out to us as soon as she could. But their investigator, how long has he had this? In June of...
You mean I should say
Detective Belknap.
Okay.
In June of 2023, Your Honor, I stood up right over there and asked this court to please put a deadline on the state's producing discovery to us. And the court said to me, Mr. Weinstein, I was just about to ask you for that. Please provide me with an order, which I did the following week. The order was not signed and entered for whatever reason. But, Your Honor, the discovery continues to be dribbled out. And the court has made no inquiry into how long has Detective Belknap had this video. Why couldn't he have given it to the state to provide to us before trial began? So that's all I want to add, Your Honor.
I do have that question. Why the late disclosure?
Your Honor, I believe in preparing for this second part of his testimony, I think he was going through his files, and I do not believe that this case was in any file regarding
This video was in any file
regarding these defendants, and he'll have to answer that because my understanding it was in I think the person whose video it is, which is Tyrese, and as he was looking at the video, he saw Mr. Williams and he sent it over. And the reason why the state did not use it in our case in chief was because we didn't know if we were going to use it.
This video
was
in any file
regarding these defendants, and he'll have to answer that because my understanding it was in I think the person whose video it is, which is Tyrese, and as he was looking at the video, he saw Mr. Williams and he sent it over. And the reason why the state did not use it in our case in chief was because we didn't know if we were going to use it. And when I sent the email over to defense counsel last week, I was very clear in saying, hey, we just got this yesterday. The state does not, at least in our initial direct, or we won't use it until cross-examination. And the only reason why we're using it is given the line of cross-examination that happened yesterday. That's why the state did not bring it up in its initial questioning of Detective Belknap, because we did receive it at a late time. But as soon as we turned it over and we advised before cross-examination, and once cross-examination started yesterday, the state, based upon the questioning of Mr. Steele to Mr. Investigator Belknap, the state decided that this is now relevant given that line of questioning. And that is why we decided to introduce this today.
Okay.
And again, when we decided, we sent an email letting them know. I re-forwarded the email saying, hey, just to let you know, I was going to intend to use this today.
When does this particular video conduct of what year? Do you know?
This is, I believe it's from 2012, Your Honor.
All right. Harvey's assertion that it predates the indictment?
Your Honor, we're allowed to, when I have a case, I'm just trying to find the actual case to give the court a cite. But we can talk about the timeliness of the enterprise. We can talk about what's happened, what predates the enterprise, in order to give a historical perspective of the enterprise. We do not have the moment in which our indictments that YSL started in 2012 after coming out of Rock Crew and transitioning into YSL. So this would be in that time frame. Additionally, Your Honor, some of the tweets that we had from yesterday, tweets that were introduced yesterday, perspective of when the enterprise began, Your Honor.
What about the narrator in this?
Yes, that's Tyrese Eggleston.
And Mr. Eggleston, does he have a affiliation with Sex Money Murder or Rock Crew or YSL that you're going to tie together?
Yes, Your Honor. We believe that Tyrese Eggleston is a member of Rock Crew.
Okay. And then the last thing is, what about the references to pounds and ounces? Can we omit those, please? If you can omit the marijuana smoking that occurs and you have some time this evening, I would say you omit the pounds and ounces references as well.
Your Honor, the only argument we would have to that, again, in this case, we've alleged that one of the acts that this gang participates in is drug sales and drug dealing. The conspiracy.
Where is that?
We also, within the narration of our conspiracy, Your Honor.
Let me look at it.
The 12 of the indictment, Your Honor.
Thank you.
And it's the the fourth bullet point.
All right. Okay, Mr. Gould and Mr. Short, your objections are overruled at this point. Last thing before I rule Harvey's issue, what about the issue of severance at this point in time as to his client? He has indicated that it has caused his client a prejudicial spillover. How would you address that?
Yes, Your Honor. Your Honor, Mr. For a severance, the conspiracy, this is state's position that he has put himself as part of this conspiracy, Your Honor, and evidence of one is evidence of all, Your Honor, and he is a conspirator in this case, and the evidence is against him, regardless of whether or not Mr. Harvey cross-examine a witness, regardless of what's coming in, he is a part of the conspiracy and therefore as well.
All right. Mr. Harvey, I'm going to overrule your motion for severance at this point in time. At the appropriate time in the proceedings as I am authorized to do so. At this point, assuming the state can lay a foundation as to state's whiskey, other than objections that have been made, I'll admit it.
Excuse me, Your Honor.
Yes.
Since this was due to us under 7.
It's continuing discovery.
Please inquire as with Detective Belknap as to when he and if they're allowed to hide behind evidence that their witnesses don't produce until it's time to testify to this.
Your Honor, we believe that the state has to be able to answer any type of cross-examination. So that's why we did not put it in. I mean,
did you did not have this video and did not know of its existence 1st of February?
The state, this table, the Fulton County District Attorney's Office the video.
Okay.
Investigator Belknap, I believe, sent Wednesday the 31st while
And why, and you're saying that he sent it only because he was reviewing it for another case?
No. I believe he was reviewing, just maybe going through his files, just really as an expert, just going through as his files at. Came upon this case. I'm not saying he didn't have it. I'm not saying he just found it. I don't believe that would be accurate. I believe he's had it. I don't want to speak for him, but I believe file, but I think you should ask him next. I do not want to speak for him. I believe the video. As he was looking through it, he watched the video, I believe saw Mr. Williams in there and sent it over. And that is when and that is why we did it in our using it to rebut what has come out on cross this witness and this particularly regarding Mr. Williams, rock crew, and the position that Mr. Williams is really a studio gangster. So it is to the cross-examination.
Found that testimony 2023 that was in his possession before he testified the first time. It's a simple inquiry for the court to find out when Detective introduced this to the state.
You're right. I believe this is a delay tactic, so we can't just but we can bring investigator Belknap in.
Your Honor, the only delay in this case is going to produce a timely.
I'll let you all talk with so you can go outside right now and talk to him. Mr. I'll give you 15 minutes to talk to him about that. And proceed. Mr. Bell? Okay. Investigate. Okay, all right.
Yeah, detective said that this 12, that in 2012 he viewed it on so downloaded it. So he has had it since 17, 16, full in custody. Prosecutors since 12 should be provided with this to start the trial. You can also
Here, say as a response. Haven't said anything yet. Mr. Atkins was out of Belknap. And when Belknap is with file, where was the file? I understand that he's advised. And again, Your Honor, this only became rebuttal examination. And I of course attention to Potter v. State, God bless you, to the -4 as a question and allow rebuttal presenting his defense. Now here, he has not presented his defense yet. How if he's left to ever in the of Mr. Steele inferred or alluded to Williams is operating, he does things from this end. With that line of cross-examination, the photographs direct line of questioning is why we have brought this video. So again, examination of those, and we're using it as a part of what was yesterday.
The statute case or rebuttal. That language is in the statute. So the fact that they're using it all we RICO case that goes in this and to say information in the catalog, Jeffrey Williams in this video, I think is this.
Have it excluded. That's not the remedy. The remedy is they've had opportunity for a week to investigate a Belknap. Right now, to they watched the video. I don't know if anyone to this, but they had it. So the remedy in this case is what has already happened, which is they do it.
The court has one for zealous advocate. Another will deny your motion at this point.
I would just like to mental principle, if you prosecution continuously my work by somehow denying him by basically not accurate. Race station. I checked whether Jeffrey Williams was helped out by Rock Crew, whether promoted by, and then I asked, and tattoo of what war. So I love Rock Crew. Why? Nothing about associating were gang members. And he said that's true. The gang's purpose, and I always relate back to Jeffrey Ryan. And Mr. Williams is not associated with people. I even asked, and I'm confident, but either knowing that potentially commit, I still say that is not a crime in and of itself. Is so Russia and Georgia. Now, it's really not.
Well, it's whatever. Yeah. Who's going to decide that issue? So I understand about the issue of the court's going to. I may decide it may be cumulative, but I'm going to overrule the objection. Mr. Steele? I'll sign that. I'm not going to sign that, Mr. Other things since in what I didn't. Earlier, and that's my fault, Mr. Weinstein, but I need all right. Detective Belknap, time. All right. Sorry, our jurors for. All right, so I need. Ladies and gentlemen, please be seated. I think. Yeah, you still gotta get up and go. Keep that for your patients indicated earlier. You with the examining investigator about that here. Okay, all right. Mr. Steele?
If you remember now, but State's Exhibit Danny with the do you know the video and would State okay, may I approach, Your Honor? Well, it's coming up, honorable prosecutors get set up, but just to say, and some sort of furniture. I'm going to say I'm not the. That sounds. Yes. And then on his index, I'm now, but it was like word a slat. Is that fair to say? Attached to what? There. If I'm trying cases of where professional baseball players doing this, it's why basketball players. LeBron James.
Yes, sir.
And how about
I don't recall
Anthony Davis?
either.
All right.
I have not.
Well, do you know the doing that is video?
I don't believe so.
You saw them today, right? Videos? football player, Dallas Cowboys?
I don't.
Find Big Bear, Buffalo. Same.
I don't believe I have, no.
And which? Okay. Trayvon Diggs, Alabama. You also do it. Anybody.
So who? Not
There's nothing wrong. That just will.
That object. You can do. Can we move on to something else?
It's a warning.
do.
Okay.
Was
And that's
the question was?
is it
Yeah.
and it's so has like an introduction I'm sorry. Both. Is it you and on it or on it. There are several that hold up. He has everyone familiar if you're not. Those featured on
shirt.
Okay, and they,
I'll tell you yeah,
live in Alabama. I'm wrong. I apologize. Again, it was too. Right. He wants. Yeah, we gonna keep him, man. Right. Really cool. Bring in with one time. Okay? Yeah. And that was what I call. There's no.
Nothing illegal in the video.
Maybe their neighborhood. Now,
Can you remember? Well, you're familiar with this bill of indictment 74. You just and song. Do you remember? If I'm no lyrics are all his with regard October 17th October years on my the beat. Remember the word. I'm certain that that's been done today, right? This is the person. disconnect Brian. Just around. No. I believe man. Trip walk. I mean, Serena. Where we have seen it on video. Great. As well. Just I can't. Yes. Okay. Um, well, you, um, you. Constitution, and if they want, then I'll go with them.
Bellman.
This said.
Number.
In order?
On your honor. That's permission. No.
Williams. Williams.
Dated.
I did. Wimbledon.
Let's see. Can you
Williams. Um,
something wrong? The 2000. All right. Wish. If hand or grab into the I'm not about that. And Sergio of you and use so yeah, that's how you gonna does bother I got arrested. In court, the person is back to court. I like case analysis. Yeah. I need time with that further. Should I get not books to world? Most popular. Please may do it too. I can aware of that. That was are you aware of in Georgia, you what and that YSL has lawyers. I don't know any dealings, but I would trade on. Work. Actual. Account change today. Okay. Sameness. Goes back. I'd like to see and what was the question? And ask you question off. What came surveillance camera. Some that say I had I'm just certain shown. If you
9 years. McDonald's. Information. Located out.
the on the joke. Okay. Gang. Sign. And you explain the red. And life. You know, there's at time that color. I'm
It might